In the constantly changing world of fundability, the big question is this: how are entrepreneurs and real estate investors like us, ones who want to grow our businesses and who are tired of paying for really expensive alternative lending, how do we tap into the most inexpensive money available and do it without the hassle of typical borrowing? That is the question, and this podcast will give you the answers. Welcome to the Get Fundable podcast with your host, Merrill Chandler.
Welcome back, everybody. Merrill Chandler here, your host, your guide, your your gate crashing opportunist to share with you things that are amazing to me, and hopefully that they'll either blow your skirts up or float your boat or make things meaningful to you. So in this episode of Get Fundable podcast, we're going to be talking about, it happened 2 to 3 years ago, or it's been happening for this entire time, but it's kind of the next phase after the Into the Madness series. I'm going to tell you exactly the rules as to what can be listed on your credit profile and what cannot, so that when you do an accuracy audit, or you have one, us do one for you. I mean, I teach in the boot camp at getfundablebootcamp.com. I teach them how to do it. In the book, I teach you the parameters for doing this. We're going to talk about the legal opportunities to for you to verify what is accurate and what is not on your profiles. I'll see you in just a second, and we'll get this party started. Welcome back, everybody. Merrill Chandler, your host of the Get Fundable podcast. So, as I said, I'm going to go through right now and kind of give you a little a little history lesson, literally over the last 2 to 3 years. But over the course of these years, it's kind of indicative. What I'm going to share with you, it tells the story of the relationship between borrowers, lenders, the credit bureaus, and then regulators and folks who have done a fairly decent job of having the borrowers back. So let's get to it. First and foremost, the thing we want to talk about is in 2015, the announcement was made Friday in May of 2015, but 30 state attorneys general sued or began a lawsuit against all three credit bureaus for breach of the common good, right? The public good. The bureaus have been notorious. I mean, they've in 1996 they were in 1995 they were 19 state attorneys generals sued the credit bureaus and won, and now there's been small lawsuits over time. But the only time that the credit bureaus make a move is when either a grip of attorneys generals come down on them, or they get bugged to death by the persistent lawsuits that consumers do, because attorneys, love them, hate them, but attorneys who have a profit incentive to go after the big data, big banking, big credit bureaus, etc., they pursue lawsuits to the ultimate victory, and we all win as a result. So let me get to this. 30 state attorneys generals literally came up against, and without going through it, the credit bureaus kind of buckled. And the premise of this of the attack of this consortium of attorneys generals, every one of them said that they do not take care with data. They collect data that is not accurate or is not complete. I say all the time, right? There's 29 Merrill Chandlers in the credit bureau databases and 13 Chandler Merrills, right? But how do I assign a particular account to this Merrill Chandler file, especially when there's 29 other of them? And remember, some people say, oh, well, they use your social security number. Do you realize the credit bureaus cannot use your entire social security number as the reference point? They're a non-governmental agency. A lender can use it because they're asking to identify you, and you wrote that number on the application, so you can use that as your relationship. But the credit bureaus are a third party. They cannot use that as part of a search string. Then there's dates of birth. So we'll get into the data of this in a moment, but something triggered this for this to come up. I was working on one of the trainings with with the Credit Sense advisor teams, and when I got back into this and training them, I'm like, you know what, this is an amazing podcast. So I want to be able to go through this with you. So bottom line is that this consortium of 30 attorneys generals reached a settlement with the 3 credit reporting agencies, Equifax, Experian, and TransUnion, and they agreed to make certain changes to their business practices. Now, I'm going to include in the show notes, and you'll be able to see it if you go to getfundablepodcast.com and find this episode, and you'll be able to see there's a graphic in there, and there's also a link if you want to get into the nitty-gritty of it. But there's an exhibit of the legal proceedings that precipitated this settlement, and basically it's a statement of facts by the credit bureaus. But over and over they say, well, we admit no wrongdoing. In the ordinary course of business, we're subject to governmental or regulatory examinations, which are the outcome is unpredictable. In the view of inherent unpredictability of litigation and regulatory matters where the damages sought are substantial, and we even though we have reserves for litigations, it comes up against our budgets to have all of these lawsuits. Just go through this. It's called Exhibit 99.2 in this proceeding. They say, without admitting any wrongdoing, we've agreed to a settlement of this matter. The court approved agreement earlier in 2008, 2009, but they also mentioned tons of little. So this document that I'm including it shows how many times, because they admit 17 million in payouts, 51 million in payouts. They're showing all the reasons why they are not admitting guilt, but all the reasons why they're willing to not go up against all of the 30 state attorney generals. Okay. So this link shows you the precursory lawsuit or legal proceeding history leading up to why the bureaus basically just buckled. Now, the bureaus have, and we're going to go over what they look like, and they're beautiful. So that's why I said this might be in part of the Into the Madness series, because it's the next logical step for after you order your credit reports and after you know how to read them. Now you know what should or shouldn't be there. It might be standalone, because it is so powerful as of what positive movements that even the giants, even the titans of industry do ultimately have to be accountable to the regulators and to the public. So so let me go through here. One of the big reasons why this came to be is that in a CFPB, which is the Consumer Financial Protection Bureau, they acknowledged that there were 76% of the 185,000 profiles that were reviewed from the credit bureaus had incorrect information, and the incorrect information could lead to denials of credit. So that's a great sample size. 185,700 were reporting complaints, and 76% of them were related to incorrect information. So these new, so big things happen. First of all, no tax liens, and this was huge. This was back in 2018 when they had announced it in 2015-16 through the litigation and the settlement process. They said that it would be the summer of 2018, but during the 2018, we literally prepared our clients, our students, everybody in our universe. We told them that, guess what? There are going to be some improvements in your profiles, and tax liens are one of the things that were like summarily removed from everybody's credit profile. And you know why? Because the 4 major indicators of those tax liens are not being transferred to the credit bureaus, and so they can't report all the accurate data that would make a tax lien mine or make the tax lien yours. So so these civil judgments, if it doesn't have collections, civil judgments, bankruptcies, and all data furnishers, we're going to go through what these what the impact is for all of these. And then you can find this in the blog, getfundablepodcast.com. Find this one. You're going to see the link to the article, and you're going to see what the PNG file, the screenshot of what I've captured. Now, some of these were available. Some of these began to be affected in 2016, 2017. Some were in 2018. But the thing is that may seem like 2 or 3 years ago, but the problem is that there are still credit bureaus and consumer reporting agencies that do not include all of this data. Data points are your business, and your data points, if they don't have these things, they reflect negatively on you. So I'm just giving you a heads up about what your rights are under the Fair Credit Reporting Act and under this ruling that's called the National Consumer Assistance Plan. Now notice, they're going to get their asses sued, and what do? They come up with a National Consumer Assistance Plan. And it comes from the settlement between the major bureaus and 30, for all I know, more people joined after the fact. All right, so let's go through these one at a time. So now this does not matter on your MyFICO report. Does not matter, because MyFICO is pulling data, the raw data from the 3 credit bureaus, Experian, TransUnion, Equifax, and then scores it. So your MyFICO report is about scoring the available data. This requires you go to the End of the Madness series, where we're talking, I think it's 3, 4, and 5, where you're actually reviewing your consumer disclosure files, the raw data files from each of the bureaus. So this is what can and cannot be listed and what the requirements are. Now, collection agencies and debt buyers. First thing, what you have to have is, if it doesn't report, what's required to be on the report is the original creditor name and the classification code. It could be for health purposes. It could be like a cell phone bill, a service provider. There are classification codes that indicate what type of the original creditor is. All right. So if it does not have the original creditor and it does not have a classification code, then you get to include it in your accuracy audit, as we've discussed in the boot camp and in my book. Okay. And in previous episodes of the podcast. If they do not have the original creditor name and a classification code, then you must, then the credit bureaus must not report that. So include it in your audit and send those findings to the credit bureaus and ask for their removal. And then you need to take screenshots or pictures or include the documents that show that those things are not included. Now listen to this. This is awesome. This is a change. Collection agencies and debt buyers must also, they cannot report debts that didn't come from a contract or an agreement to pay. Like, you can't have collections on a traffic courts or traffic tickets, court fines. I'm even going to push the envelope and say, if there is not a promise to pay, if you receive a bill that was not part of an arrangement, they cannot record that as a collection on your credit profile. All right. Now, here's the other thing, and this one, most collection agencies and debt buyers, most of them in the past would buy and download a complete file, and they'd pay whoever, let's call it, they'd pay Chase 10 cents on the dollar, 20 cents on the dollar, and get a download of all of these people who were in charge off or delinquent mode. But the reports were one time. They'd literally, and the credit bureaus would list them once and never list them again. Collection agencies and debt buyers, they would literally put it on a credit report and never have to do anything, right? Now, as a result of this settlement, they have to report the full file every single month, which includes the data points that I'm going to share with you in a moment. So if every collection agency had to either get out of the business or start reporting monthly on the current status of every collection account. Now, that's it. In my world, from my perspective of 27 years of this, that's good news, because you cannot, you do a validate and verify, more on this later. You can't do an audit of a file that's 3 years old, but there's no current reporting data. So having to report, and if they can't report it every month, it doesn't get to be put on your collection account. That's why back in 2017 and 18, when all these were being enacted or executed, literally there were dozens and millions and millions of collections, and trade lines and judgments were all being removed from credit files. Okay. Now, listen to what this says. For credit bureaus will exclude public tax liens, civil judgment data that do not conform to the data standards we're going to be talking about in just a moment. That means if the data is not there, when they receive it from the public record, and that's usually LexisNexis now, but we'll get into that in a sec, the credit bureaus have to exclude it. That means if the data is coming to them for public tax liens and civil judgments, if that is coming to them and they don't have all 4 data points that we'll discuss in a second, they have to reject the data from coming in and can't put it on your file. All right. Then back to collection agencies and debt buyers, they have to report and delete for accounts that are being paid or were paid within or paid in full through insurance. So one of the things that was horrible, let's say you go to the doctor. You go to the doctor and they charge you $5,000. And then your copay was $500. You paid your $500, but then it took you guys know this, it took a month, it took 2 months, it took 3 months, it took 6 months for the insurance to pay it off. Most collection agencies that were getting these would literally, that $4,500 after the copay was borrowed, they would say, you owe us $4,500, and it would be sent to collections. Now they cannot do that. They cannot report even accounts that are being paid or were paid through insurance. Those are completely taken off. So whole new data requirements necessary. So if someone is, if you are in the process, because it says being paid or were paid in full through insurance, they can't report those. So if you are in the process of working with your insurance company and they do, and you get a collection, but you show current relationship with the with the insurance company that you're in the process of reconciling all this, must be deleted. Must be deleted. And if it was paid in full, then of course it has to be deleted, because it was never a collection. It was just the process of getting through the insurance claim process. Okay. Now, here's the next one. It says in here in the report you're going to be the screenshot you're going to be seeing in the Get Fundable podcast blog version of this says all data furnishers. Now, a data furnisher is any organization that reports account information. It could be trade lines like credit cards, installment loans, etc., or reports public records, or reports collections. There's three types of reporting structures. One's called trade lines, and those are your revolving installment loans. Then there are collection accounts, and then there are public records. And the public records come from the public record, from the courts, from the judgment or the lien or the bankruptcy, etc. All data furnishers, every data furnisher out there has to report, make a note of this, the full name, the address, social security number, and date of birth. Those 4 data points. If there is any trade line, collection, or public record that does not have all 4 of those. Now, when they say the full name, that's where we talk about, and that's where you need probably some high performance coaching on building your PBID and then auditing for the PBID, and then you send the accuracy audit and the disputes to the bureaus, right? But full name, address, social security number, and date of birth. If they do not report all of those, they cannot report that. So if something ends up on your consumer disclosures, remember you're working all 3 consumer disclosures. If all of that information is not there, if it doesn't synchronize with your PBID that you've chosen and sent to your positive reporting lenders, then those have to be removed. Now, the reason why this whole opportunity came up, because as I said, I was doing a training with my accuracy audit, the accuracy audit team at CreditSense. Now, what's hilarious is one of the data furnishers that is not well known is called LexisNexis. And back in the day, courts or credit bureaus used to collect data from the courts, and then they would report that data as they collected it. And if you've been into the court data, it's not always pretty. There's so many things that are missing. It's handwritten, interpretable, whatever. So, but now, as of early 2000s, there was a range at which it started and then came to full fruition. But credit bureaus started receiving the data from LexisNexis. So LexisNexis collects it from directly from the courts and public records, and then reports it to the credit bureaus. Funny thing is, the credit bureaus now are receiving data from a third party, not from the source, not from the data source, but the data furnishers. And data furnishers fall under this rule. So that means, so we were reviewing in LexisNexis consumer disclosure because LexisNexis has raw data files just like any consumer reporting agency is legally obligated to do so. We were going through LexisNexis, and I was teaching my team how to look at every single thing that's mentioned. If it doesn't contain all 4 data points, name, address, social security number, and date of birth on each line, it isn't. You can't have a social security number here and a date of birth here, and all of them have different addresses and blanks. Those don't get to be reported. And in that accuracy audit, you get to send those findings to LexisNexis, and then when you reconcile that data furnisher, then new data gets reported, or the data is then removed from the credit bureaus, because LexisNexis is the data furnisher, and they have to obey the same rules that the credit bureaus do when it comes to accuracy and filings. So this section says all data furnishers have to do this thing, all 4 of those. Now, how to do that with your PBID? Go to the boot camp. I'm serious. Grab my book, getfundablebook.com, getfundablebootcamp.com. Go there and learn how to do these. In the boot camp, we actually have the auditing materials, and so you can send the findings to the credit bureaus, dismissing what shouldn't be reported. You get that as part of the gold and silver memberships, or gold and silver event pricing. So make sure your data is accurate. We've talked about this for 60 podcasts now. Make sure your data is accurate. Now, the very last one is reporters of authorized user data. So if you're these are really only credit card issuers. If you report authorized user data, you have to include now a full date of birth for any and all authorized users on the account, or it can't be reported, because that date of birth is designed for accuracy, to separate the card holder, the owner, the individual owner of the account, and the authorized user. So if it doesn't have the date of birth for that new authorized user, you can't put it on the credit report. Now, that helps us when we're doing an audit, because ultimately authorized users are relatively meaningless. As the book says, as the boot camp says, as I've said in previous podcasts, guys, being an authorized user is no bueno. It helps with your score, but it doesn't do a thing. It actually punishes your fundability. And remember, I don't care about scores. I care about whether or not a lender will give you money. So these are so good news. Over 2016, 17, and 18, while this was all being implemented, people's credit scores were improving. But the thing for us, for fundability, is we want accuracy in reporting. And if we're pushing these kind of limits, if we're looking at our consumer disclosure files and we're finding out where they do not meet these regulations, gonzo. Accuracy, everything, guys, and you've got to get them You've got to get them to stop reporting these on the credit bureaus, so that when FICO filters that data with its scoring software, you are fundable. This is Merrill Chandler, your host of the Get Fundable podcast. I hope you have as much fun as I do listening to this. And if you are literally binging this, then keep going, because we have so many things to cover that continue to impact you, to make you a professional borrower instead of a rookie borrower. Be well and have a spectacular rest of your day.
Thank you for listening to the Get Fundable podcast. Please leave comments, because Merrill would love to read about your aha moments from this episode. And be sure to visit getfundable.com to read our blog, get important links, join our community, and much, much more, like ordering Merrill's tell-all book that is changing the world, The New F Word. And you got to tell your friends about this podcast, because we want them to get fundable too.